point, but we will continue to try. And assuming that a proposal like this may move forward, we also want to be engaged in that process and try to make it as good as possible, right? So our main concerns, outside of just the general use of facial recognition technology in schools, on the first area, we have a concern, and I know we got some information and some tweaks to this language that was originally proposed after meeting with some folks that ties it to the Student Data Transparency and Security Act. I think we still have some concerns there. Our main concerns were around consent from the student and parent before the use of this technology and collection of this type of data by schools for curriculum use. In a fairly quick read of the current statute, it seems as though consent is only required if the vendor is using that data for purposes outside of the contract with the school, not for purposes within the contract with the school. So we would still have some concerns around not necessarily there being an already statutory required consent. And then the other area was also the retention piece and wanting some pretty specific retention timelines in statute. Our read of the current statute is that the retention timeline is based on the contract with the school and the vendor, and it isn't actually in statute with rigid timelines. I think the most specific portion of that is if there is not a timeline in the contract, then the vendor has to delete the data once the contract has ended. But beyond that, it's effectively whatever is in the contract with the school itself or the school district. And we have some concerns around that in regards to like such sensitive data. And I know biometric identifiers we're pretty clear on timelines in that and in the CPA. I don't see the same clarity around timelines in this particular statute that we would like to see when we're talking about this type of data specifically. And then on the other portions, we do have concerns, and I voiced these around the use of facial recognition technologies by schools in situations where we think the most appropriate entity to be utilizing it in those situations would be law enforcement. Just based on training, understanding of not only like the impact and constitutional rights of the individuals involved in the facial recognition technology being used on, but I think also in response. We're concerned that if schools are using this technology to identify an individual who may be a threat and law enforcement is not involved in that moment, what happens once they've identified the individual? Like, they know who the person is. That's great. We don't see that as removing or minimizing the threat that exists in that situation. So we do continue to have concerns with the situations in those, and just a more nuanced question on the student absconding piece, just for clarification for us. A little confused on how facial recognition technology would be used if a student absconds off of school property, like a field trip or a situation like that. Assuming that the facial recognition technology would be on school grounds, we're unsure of how it would be helpful in those particular situations outside of the actual campus.
That's where Mr. Cook's Google Maps car comes in. Drive around. Super great kickoff to this discussion. Mr. Cook, or do you want me to go back to Mr. Schaefer?
Yeah, I was just gonna say real quick, we appreciate the interaction we've had with the ACLU and other members, folks who have interest in this. I think as both Representatives Jones and Senator, sometimes we craft the best language we can't account for every instance. And so I think for the law enforcement piece, obviously, schools work very closely with those folks. So I think the identifiable piece would be, and Brandon, correct me if I'm wrong, with somebody has a restraining order and they show up at school. And so that would be the point that we would engage law enforcement. Yeah. The other piece I would just say is House Bill 1614-23, and there are some very rigorous language in there around a lot of the things we're talking about. So I think a lot lifted maybe a whole cloud.
A reference to it, yeah.
Exactly, so.
Okay. Thoughts on the cross-referencing the 1423? Do you feel like that's a good spot for us for some of the questions you just raised?
I think our concern lies with our reading of that bill and the statute from it. It doesn't, and there is the potential that we miss some things. That bill didn't seem to contemplate biometric data. So I don't know that it actually contemplated the protection and consent requirements and retention requirements to the level that we would feel most comfortable seeing when we're talking about biometric data specifically.
I mean, we were still using fingerprints to open our phones back then.
Right.
That's an interesting point. So there may be a need for cross-reference and type of situation. Love to hear from the schools on the kind of consent retention piece, and if you think that's a map for us here.
I do, so do go back and look at that particular bill. Consent is mentioned several times, both parental and student consent. And we do that quite often. When you send your child to school, you get the handbook, right, that says if you'd like to have your student pictured on a website, for instance, you can consent or not consent to do that. So I think schools are very familiar with that. The retention piece, I think for when it was written, which 2016 doesn't seem that long ago, but you are correct, there's probably some updates. But to your point earlier around the AI piece, I think as we move forward, right, we're kind of on the bleeding edge, so we may not be able to anticipate everything that's coming. So I think we'd be open to some conversation around the retention and the destruction, but I think the bill currently does provide a solid framework.
Yeah. President Schaefer, anything you want to add?
Yeah, thank you, Mr. Chair. Just a couple responses. First, let's be clear, that 2232-150, this is the prohibition that's already in statute. That is based on a contract with a vendor. So, except as described in subsection 2, a school district or school or a charter school or school district shall not execute a contract with a vendor for the purchase of. That's the prohibition that goes into effect. So to be consistent with the language of the prohibition right now, it actually makes sense to have the restrictions be contained within the four corners of the agreement with the third-party vendor. Now, what you'll find is that almost all contracts with school districts, or any governmental entity for that matter, are one-year contracts with options to renew. They're one-year contracts because of the Tabor Amendment. We're not allowed to execute a contract that makes a multi-year financial obligation on the school district. So every year, every contract with the school district is a one-year agreement that then gets renewed if we have the funding renewed through the state budget. So if you were to interpret the logical sequence there, the data would be destroyed every year at a minimum. If you want to put that in black and white in the statute, I don't know that there'd be much objection, although vendors, if they do have a multi-year agreement, recurring contract with the district, oftentimes will say, look, we can't recreate our database every time you want to renew the agreement. So we have to get some input from vendors on how best to do that. But in terms of the time frame for when the destruction schedule, it's usually an annual process to destroy the data, or to renew the contract is another way of saying the same thing. Trying to remember all the comments. I will respond to the situation where a student absconds, it's not on school grounds. Yeah, the facial recognition, the technology wouldn't benefit anybody under those circumstances, so we wouldn't use it. But if you are talking about trying to find a student in a school who's hiding somewhere, or somewhere that you didn't expect them to be, it would be a very helpful tool. The last comment I'd make is around rural schools. Um, when you're talking about exigent circumstances, when you're talking about an individual who is threatening to hurt people inside a school, it's not minutes, it's seconds that matter. And while it'd be really nice to be able to confer with law enforcement before flipping the switch on your device to activate facial recognition, it's not always going to be an option. Be more, we have more of a police presence in schools in the metropolitan areas. So we have SROs at most of our schools. The exception is our elementary schools. We don't have an SRO in every elementary school, but we have one. We should have two in every high school, and we have one in every middle school. You get to rural parts of the state, that's just not a reasonable, feasible alternative. So, there are the scales of justice here, right? We have to balance interests. And that, I would suggest to you and to the rest of the committee that the right balance is to the safety of the students in the school. And giving a school official, whether that's an administrator or a teacher, the ability within their professional obligations to judge a situation as dangerous enough to justify flipping the switch, turn on the facial recognition, so I can harden my school and ensure the bad guys stay outside. I think that's a tool we want to give our schools. Because unfortunately we have too many circumstances, too many situations where individuals have actually come into schools with guns. Right? A lot of the concerns that are raised are very valid hypothetical concerns. On the other side of that, we have real people with guns who are threatening students and teachers and administrators in our buildings. Where are you gonna? Which side of that equation are you going to lean toward? Is the discussion I think that needs to be had, and if you're going to err in one direction or another, please err on the side of protecting students.
All right, Mr. Parker?
Yeah, just I wanted to commend the School Boards Association for a lot of honestly and thorough work on this and crafting an exception here that's very, very specific and very narrow. I really think it makes a lot of sense. The doing this, I think, was mentioned. PII of students is already covered under existing law, and with respect to the privacy expectations of everyone else, visitors, and others, this doesn't change anything. I mean, anytime you enter a school campus, you're being recorded on video surveillance, and when you look at the three purposes A, B, and C that are laid out, these are, at least the initial response to these things, are core school responsibilities. These are not law enforcement responsibilities. And currently schools are using their security systems in part to help do these things, to respond to these things. And as I mentioned in some of the email back and forth, I mean, most modern systems like that have had the capability to use this technology for many years. What you're basically saying is you have to not use something you already have, where you actually be able to do these things much quicker and better as far as protecting students, finding someone who's missing. And the example of or the question about, what about off campus? I think where it would come into play is, yeah, of course you only have the areas of the school campus to look at, but you would be able to see where a student left, what direction they were heading, what happened right before that. So there's a lot of valuable information you could gain, and just a little bit of maybe explanation about how the technology works. It's pretty simple, really, comparing it to like a Google search on the internet. So you have your video system and the recording. You can search that just like you would with a Google search to find something you're looking for, and you're going to get results that are probably what you're looking for, and maybe some that are just similar. But you can also set Google alerts, where if something appears that you're looking for, it will alert you. And that's very similar to how you would use the system. But also you would usually group images together, basically find things in footage that you were already doing without it. It's just manual and it takes forever, and maybe it's not very accurate if you've got humans doing it, or unaided by this additional technology. So, it would definitely support the proposal here.
Go ahead, Rick, tell me.
Is it the intention of the schools to go beyond just the facial recognition to object recognition for firearm identification as well? On top of what,
Yeah, we don't have to be overly formal here, so yeah, we can have a conversation as a committee. I just wanna make sure I didn't miss people on those Zooms, so, yeah, go ahead, Mr. Cook.
Representative Tone, what I would say is, it's my understanding that there is technology that can do that. I don't have any idea, right now, I can certainly find that information out, if schools are doing that. But I would imagine that you probably could program it to do that, I just don't know that.
I mean, Google can identify objects, already, and I guess my point is that, we are focusing on facial recognition, and maybe we wanna make sure that we're not stopping any other type of thing from being included in that recognition, or do we wanna actually spell that out, that that is an allowable thing, and what are the risks to doing that?
I think it's a great point, and certainly one we'd be willing to explore, at least from school boards, I think, for sure.
Yeah, comments on object recognition?
I think there is or was another debate around gun detection technology earlier this session, because I don't know where it's at.
Yeah, go ahead, Mr. Phipps.
So, Mike Fitz, Department of Revenue. So the object recognition, as of last year when I was involved in this, there's at least one vendor out there that is a subscription service that will tie into your current cameras. They watch the feed, they run it through software. They have people who, when something gets flagged by the software, go on and do a physical confirmation of it, and then have an ability to instantly text the list of people that you provide them back to the school. So you have, that's already there. It's working off of the same hardware as the schools. I would imagine that somebody's going to make their camera systems capable of doing that, so you don't have to pay the extra subscription. The same thing, same camera systems can be done for license plate recognition, so that you can recognize license plates come on. Most frequently, it's being done in higher education to flag violators who have parking violations, repeat offenders. When I was at Auraria as the police chief, we would, on occasion, for the people who are identified as having made credible threats to the school, we put their information about their license plates into our parking system, so they got flagged when that car would be on campus and our LPRs were going around doing parking enforcement, but it would flag so that we knew a vehicle associated with that person's here, likely they're here too, we need to up our game, right? So as you talk about the expansion of AI for this committee's work, these things are all tied together. I think this started out with the idea that we wanted to protect people from false identifications and being falsely arrested, and all noble causes. But we are already 3 years behind on all the other stuff that these systems can do to make sure we're regulating them. And then I had some other comments, but I'll make it for Tom.
Yeah.
Right away.
Well, let's park that for a second. I wanna go to Mr. Parker, and then we'll come back to you.
Yeah, I was just going to say on this weapons detection question. So, yeah, there are a number of vendors that offer that type of service or capability. It often has used this security system, but these are not the same things. That does not involve facial recognition. So that is definitely involves some AI, powered software, but it is really unrelated to what we're talking about here.
Any thoughts? I mean, what if the firearm doesn't give consent?
I don't know that we have a problem with that.
Yeah. Just take a joke about these serious matters. So.
Yeah, we don't, I would have to do some research on that, because we don't do a whole lot of work on policy. So,
Yeah, Mr. Phipps.
But once you identify a person with a weapon on campus, you can grab stills of them and make them searchable for where they are now by every camera on that system. So in a way, they are tied together because one leads to the next if you have the right technology available, because the weapon may then become concealed and and not being picked up by the software, but you know what the person looked like, and now you put in a picture of them, and the system is now identifying and going through every camera as quickly as it can, looking for anybody who matches up by either the facial recognition, the gait sometimes, the clothing. There's a lot of ways you can set the system up to identify what that is going on. If they get into a vehicle, it could be looking for a vehicle that matches the description of the two pictures you gave the AI for that vehicle. So they are tied together in a way. One leads to the next, and it is exigent circumstances type things.
Yeah, I mean, this is a great example of like pull the thread, and we are quickly going to get into important related topics that are closely tied to the main facial recognition idea. Well, I guess just to insert, I think as I signaled, I think not to speak for Reptitone, but I think we're in a similar spot. Like if we can come to some kind of agreement here, I think we'd be very happy to try to move something forward. Certainly want to make sure we're lining up with the PII and the privacy pieces, the consent and the retention pieces. I'd love to see if we can come up with a package that everyone feels okay about. And you know, I think that was the intent of this entire task force, was to try to see if we could make incremental steps in this space. You know, as my dad would say, measure twice, cut once. Like, are we trying to measure twice here? I sure hope so. I think we have. And so wanted to maybe just check in with the sense of the task force, particularly with ACLU. I mean, do you feel like we've got a path here to head in this direction with the appropriate safeguards?
I don't know that we would feel comfortable with the current timeline of session to move forward with anything this year, with the amount of, I think, like really important deep diving into how this would actually be implemented, how it would be implemented responsibly, and who should actually be responsible for different pieces of this. I know we are very likely in the slim minority on this task force in this particular area. So again, we're likely not on board, but we are more than happy to work with the task force and folks moving forward if something were to move forward.
Yeah, I appreciate like your priors are, here's our national position. Like, yeah, totally get it. Like, here's our starting point. Yeah. Other folks online want to share your reflections on where we are?
I'll just chime in here. Is it possible to have OLS kind of dive a little bit into this, to cross-reference some of the other bills and statutes that we talked about, to understand a little bit more about how those things tie into it, and then maybe we can get some more feedback for the ACLU on, and understanding that you may not be totally there, but looking to just help us set the guide rails up in a way.
Yeah, I think the answer is yes. I think it's one of those things where obviously OLS is awfully busy right now. So I think it would require a bill request, which I am happy to do, so we can go down this, you know, process in a more formal way together. I think it'd be hard to do as a side research project right now. I think we either have an active legislative effort this session, and so want to get a sense of the task force on that. Obviously,
And it doesn't mean we commit to
Yeah.
the bill. If we
Yeah,
do
just
have a
give-
draft, so does the draft be up to the secretary?
Yeah. So I guess my hope is before we wrap up today, we get maybe even a straw poll or vote of the commission. Do we want to try to start drafting? If so, we can put in a request and say, hey, this is coming from the task force. We'd like to draft in this area. You know, we'll look at it together before we introduce, type of thing, similar to what any other committee would do. Yeah, same thing we do in JTC. In fact, we could take it through JTC for that matter.
Yep.
As the other option. Yeah, that's true.
Obviously, Gatsby would be in favor of that.
Okay. Mr. Johnson?
Thank you. Understanding that there's a possibility we can kind of initiate drafting a bill, but personally, I'd be comfortable with that. But one thing also I was going to suggest or ask about is there's essentially four different provisions that are proposed here. There's subsection 4 and then the three subsections to 5. And they don't necessarily all need to exist together at the same time. And looking at these, it seems, at least to me, that 5, B, and C are incredibly narrow and for a good purpose compared to 4 and A. Again, personally, I'm comfortable with all of them, but it does seem at the very least that 5, B, and C seem incredibly narrow and do have a practical and good implication, whereas even if the whole thing doesn't go through, it might be worthwhile to look at just those two individually.
Yeah, I hear you loud and clear. There are different parts of this which have different levels of specificity and difficulty. I mean, that would obviously play out in a normal legislative back and forth anyway. So I guess, yeah, let me check in with other members on the subject. Should we draft or not? Mr. Park.
Yeah, I mean, I think it's urgent. I mean, I know this, perhaps the school boards could speak to this, but I mean, the posture that we're in right now, I think probably is causing some confusion out there and delay of things that need to be done to build these capabilities or use them. I think it's urgent back, start something.
Okay. All right. Mr. Nelson, anything from your side?
Focus will be more in the second half, just making sure we're clear on the scope. But for this topic, I guess my only thoughts would be, do we have enough runway left? Do we have enough time to submit a draft with the legislative schedule we have ahead of us?
Well, I feel like I've done way more than this in the last 3 days of session. So, yeah, we got tons of time. Yeah.
Some sections in other states are like this.
Yeah, that's right. Yeah, that's right. Wyoming can do 3 sessions in the amount of time we got left. So. Isn't Texas 30 days or something? Yeah, Mexico's 30 days. So the non-budget or the budget session is 30 days. Yeah, plenty of time.
Yeah, I think we absolutely have time to get a bill through. I'm concerned that we can get it through in like a well and responsibly stakeholder manner.
Yeah. To that point, I mean, this is a relatively narrow set of topics, I think.
With I would argue, a lot of stakeholders.
Yeah.
Sorry, I'm sorry.
Yeah.
I would just say, I mean, we intentionally were very narrow, obviously, because you're right, there's a lot we could have said, hey, but our intention really was obviously on the K-12 piece, and hopefully, I think, again, these are pretty specific, and while there's a pretty large stakeholder group, I think we've effectively reached out to them fairly quickly and get some input for sure.
Mr. Roach.
Katie Rubish, legislative council staff. I do want to be clear, the task force itself does not have bill draft.
Right.
So just, JTC does, of course, so we could do
Yeah.
either way. Third.
Yeah, and are we restricted to the number of times we can meet as a task force?
No, we have to meet up to 4 times.
I mean, it would seem if we're going to move forward with a draft, we would want to meet again
Yes.
to look at that draft.
Yeah.
Get everybody's input on the draft. So I think that would necessitate a meeting probably in early April, which gives us a whole month
Yeah.
past the. All right, Mr. Cook, anything else?
No, sir, I think that covers it. Appreciate the commission's time and everybody's input. It's been a good process.
And I will say, I'll make sure, or we will make sure at JTC, if we go that direction, we can chat about the best way to do this, that we look at those interties to the previous legislation, retention, PII, the protections already in statute, and do those need to be updated or adjusted in some way to cover the situation we're looking at here.
And what I would suggest is, if we do end up moving forward with the bill, we can have, if the have any questions for the other members on the committee to,
Yeah.
to discuss.
And it seemed like we could just schedule a hearing, right? And
Yeah.
Make sure everybody's invited and be a good, and just have a formal conversation on the mic for,
It was either
Half hour.
Tuesday or Thursday.
I'll invite donuts.
So,
All right, yeah, you're here anyway, what's it?
Yeah.
Excellent point. To the other commission members, does that sound, okay, or any major process issues there? Cognizant of everyone's time, location, day jobs, et cetera.
JTC meets before 9 o'clock.
Yeah, just fair warning. All right, very good. Well, if it's all right, then let's go on to our last agenda item.
Good, I just had a couple of
Yeah, please, yeah.
So the agenda said that this was for higher education and or if this is related or this wording is going to apply to higher education, I had a couple suggestions for how it might be improved. So under B, 5B, it says a student, I would suggest maybe you change it to a juvenile. You could have people on institutions of higher education that are not students there, but could also be concerned, and then I'd also add that it's a student who's missing or so forth, or an at-risk adult. Those would be good reasons to do it. And then down in C, order to stay off school district property, maybe institutional property or some wording that would include institutions of higher education as well as school districts, or different definitions of who owns the property might be helpful.
Okay, so I hear you saying though, you'd like to include higher ed in this discussion.
It was and or, and if the discussion is to talk about adding higher education, these are also good rules for higher education, just for K-12 as well. Higher education is mostly adult learners, and a little different, but you still have the same thing. If we didn't have worries, you wouldn't have every school with threat protection teams that have to meet every week and review files of students who are having a difficult time or not emotionally regulated or other kinds of problems to deal with. And those threat assessment teams always include law enforcement and attorneys and faculty and other kinds of people to get as wide a view of what the scope of the problem is there and who's best to address it. So what's been called out here by the schools is all good for higher education too. And so if you want to use the same wording. And then on the data destruction question, I have raised with this committee a couple times that I don't think the school district should have long-term retention of this, nor should higher education. However, destruction at the end of a contract, if it's done by the year and then you have to renew it because of CABR requirements and those kind of things. There are people who are threats to the school, who've been trespassed, who don't just stop at the day a contract ends and now you don't have to worry about them. So I think that there needs to be a little bit of an extension of that. I think a 2-year window after ending their formal relationship with the school or the institution seems fairer. When I was at Auraria, we had a guy who'd been causing problems on that campus and threatening a professor for close to a decade, and showed up, and we happened to catch him with rope and weapons and other kinds of stuff trying to kidnap this professor. So, he had been tormenting this woman for a decade, and we've been trying to work on it. So this doesn't always just go away at the end of the year. Just because somebody graduates or they would have graduated had they not left school or been thrown out of school does not make them less of a threat because of contract.
All right, love to hear quick thoughts on folding higher ed into this approach. Ms. Burke.
Yeah, I would just say that I do agree that these narrow specific purposes do translate directly to higher ed as well. Just to jump in.
I think on the contract piece, I think in reality that makes sense for it to not be at the end of the contract. My question though would then be, in my mind, it would make even more sense for this to be an authority under law enforcement as opposed to schools. Because in that case, if the contract is ending, those schools wouldn't have any reasonable access to that data after a contract ends anyway, whereas law enforcement statutorily could.
Unless the data is owned by the school and not the.
Right, but if it's owned by the vendor, I'm assuming if we're talking about it having to be deleted at the end of the contract, it's because it's being held by the vendor, not by the school. In which case that school wouldn't have access to that data regardless, outside of law enforcement intervention.
And I mean, I guess the question I would ask is, are we clear as to who owns the data to begin with? Is it the vendor or is it the school? And
Yeah.
is there any statute that would indicate that that's the case?
Yeah, I feel like that's something we can get into if we move forward with drafting, and I feel like we can highlight those questions from drafting, see what the baseline is, and see if we need to make adjustments.
Because we could set the ownership of the school.
To keep the data, you have a service cloud base, at the Prairie Campus Police Department runs the entire street system, and it all belongs to the Prairie Campus Police Department. That's not the case for Douglas County Schools, it goes through their security office, and the Douglas County Sheriff and or Castle Rock, Parker, Lone Tree get involved, and they share it, they have access to it as a login, but they are a guest on that system, not the owners of it. So this is not going to be a universal thing. I think that the stakeholder need to ask people, how are you managing this data? Who owns it? Who gets to access it? Is important questions. I would be, as a person worried about my privacy, I would be more comfortable with the school retaining it for 2 years than law enforcement. Once law enforcement has it, it's open to a whole bunch of other uses and things beyond that, beyond school security. So as somebody worried about privacy, I would much rather the school have it for the people they deal with, and then it gets deleted by them than to be put into a larger system.
Yeah, and I was talking purely in instances where based off the contract, the vendor would be the owner of the data, in which case after the contract ends, the school wouldn't have access to that data anymore because they wouldn't have the contract. But law enforcement for investigative purposes could have access to that data.
I don't think the vendor should retain it anyway, regardless, that they're a private entity and shouldn't have access
But they
to it.
should be able to transfer it too, if the contract ends.
I think there's just a lot of nuance there.
Yes, all the easy bills have been done. All right. Let's see, President Schaefer has come.
Thank you, Mr. Chair. Just real quick, thinking about statutory website, I don't think the prohibition that we're talking about applies to higher education. The section of statute that we're talking about, CRS 2232-115, and that is specific to school district or school or charter school, public school districts, and shall not execute a contract with a vendor for the purchase of or for services related to facial recognition service. So where we become concerned is if we have a contract for the purchase of computers that have facial recognition, but if we have a contract for the purchase of software that uses facial recognition or drones, products, something that has facial recognition in that, that's where it becomes problematic for us. But as I'm reading this, it doesn't apply to higher education. There might be another section in the statute that you all passed that adopted in 2022, 150 in the first place. I think you did that in 2022. For some, have an entire section in front of me. But at least on the surface, what I'm saying doesn't apply to higher education.
All right, that's something we can definitely check as we look at this draft. So I'll ask for help with the drafter on that if we get permission to start drafting.
For a draft.
Yep.
We need to get JPC to
Approve drafting.
getting the draft,
Yep.
so we would have to get that on the schedule.
Yep.
Pretty
Right away.
soon.
Did you prefer to go in that direction?
I don't know how else we're supposed to get a bill and then a late bill, and those are hard.
Yeah, I mean, I think this is one of those perfect examples of when you need a late bill, but I would prefer to do it through JTC, so I think it's the right people involved in the conversation from the start.
It's the area of expertise
Yep.
and oversight.
Okay, well, we will proceed accordingly unless I hear any strong objections. Of course, noting the ACLU starting position.
We're,
Yeah.
I mean, we're also happy to collaboratively work on bills when we are in opposition to them.
Yeah.
It's not a thing that we don't do
That's
regularly.
how this place works. That's great. Okay, let's do, I wanna see if we can wrap up here, in the next 15 minutes or so. Let's take a look at our current scope, and I asked Mr. Rubush if we might be able to throw that up on the screen, to see if there's anything, in this bill that we might want to do to adjust scope. Yeah, it's all right. But I wanted to have a short conversation on whether or not folks think we need to make some adjustments here, given the adjacencies that have come up over and over in our discussions. Do we have an expiration in the statute? Oh, yeah, we got some runway, y'all. AI should be all figured out by 2027.
We could have AI do it legislative work.
That's a good point. That's an excellent
We
point.
actually, none of us will have jobs anymore.
Yeah. We'll be in Italy in our dollar houses. All right.
Very focused on facial recognition.
Yeah. If we go, if we go down a little bit, what anything else in additional duties we should be looking at?
It's not really about the additional use, not really about what you can study, it's more about how.
How does it work?
Oh, gotcha. Okay. Well, let me just throw out for discussion then. Do we feel like, this is very focused on facial recognition? Do we want to put an and in here of any sort? Mr. Parker.
Oh, I just was remembering that the way the bill was originally introduced, I believe you had an AI component to the task force. So you could always go back and look at that original version. I don't have that in front of me right now, but I think that's, so I just know that many states are actually standing up task forces on AI to make legislative recommendations. So it's certainly in line with what other states are doing. I also wasn't sure, I've heard there was pretty broad scope AI legislation potentially being introduced still this session, so I didn't know what the status of that was and how that might interplay with what we're talking about here.
Yeah, I guess I suppose it's sort of a question back to our colleagues, like, hey, do we want there to be a place for regular discussion with community experts and stakeholders in the interim? The thing, when I've seen interim committees work well, it's stuff that requires a lot of nuance and expertise. And we've got a ton of that already built here. Do we want to broaden our scope and maybe add a couple seats with some other expertise? Feels like a good idea to me, but that's what I want to discuss for a few minutes. Go.
I would say, since the task force exists, and it's a lot easier to change a task force than to stand a new one up.
Yeah.
That this is an opportunity, we even have an expiration date that's far enough out that,
Right.
if we find a groove and we need to extend it, we can even do that.
Right.
But as I've been talking a lot about AI with the tech companies in particular, a lot of the things that I've been saying to them and encouraging them is to say, this is a conversation that has to go on, and it has to be collaboration with the tech companies and the legislature, because we don't know what's coming next, and we can't regulate the bad actors without the cooperation of the people developing the technologies. So having a place where we can have those conversations and guide ideas for the legislature to do, and have this happen on a regular basis, I think is a really good opportunity that we already have and we can expand onto, and we can even do it with the bill we're talking about.
Yeah.
To make these changes. So
Yeah.
that's where I'm at, and I think that that this ongoing conversation has to happen. And I think that the tech companies agree with that, because they want to continue to grow what they're doing in AI, but they also don't want us to regulate them we don't wanna have to over-regulate and stop good technology from sure performance.
Yeah, Mr. Cook.
Sorry, I echo everything Representative Tom just said, and also say that this particular topic has been bubbling up, so to speak, nationally for school boards, school districts. And it's one that's not going away or probably be resolved anytime soon, so I would be in favor of expanding the scope and bringing some additional experts to the table.
Other thoughts there? Anything? Do we have some consensus on that idea? Any objection?
I would agree. We're happy to be a dissenting voice in a broader conversation.
Core competency. Well, then let me ask each of you to take a look at the current makeup and tell me who would be missing or is missing if we widen the scope and we include broader AI topics. Who else needs to be at the table if we go to that broader scope? And we'd love to hear from everybody before we meet next. So that
Can we throw things at the wall now?
sure.
I would say, an expert in the First Amendment. Right? Okay, right.
That's what we do.
And probably somebody from the Tech Association or some other technology, like the companies that are producing
Yeah.
the AI technology need to be in the room to talk about what they're seeing, and because they're gonna have the inside information about what the bad actors are doing, hopefully before they'll tattle on them to say, hey, look, these guys in this area are doing things that could really damage the trust that we're trying to build in AI, and this is an area that you need to regulate. So I think we need to have those partners at the table.
Yeah, and I was gonna say too, there are civil liberties focused tech groups and associations that kind of are at the intersection of what we do and what tech companies do. That might be a good voice at the table.
Yeah.
Can understand the nuance from both angles better than just one or the other.
Yeah, that sounds good. I mean, I'm very leery of, too big is a problem too. We've got some vacant spots here that maybe we don't continue. That's one way to refocus. So we might be able to have a couple of spots that we repurpose. I'm leery of getting over 19 as a max. Yeah. And what are we at right now? 15? Yeah. So if we bump up a bit, it can't be very many. But we arguably have a couple spots that we might be able to repurpose. So, okay. Well, please let us know
Yeah,
about that.
Two hands up.
Oh, a couple hands up. Yep. Who wants to go first? Mr. Parker.
Sorry, I was going to say you should definitely consider including the Colorado Chamber of Commerce. They have a technology-focused group, and they've been, very involved in discussions. That type of group around the country. We would love to continue to be part of the conversation as well as we're playing that role also in other places. We have a lot of AI-focused companies. So.
All right. Thank you, Jake. Mr. Nelson.
A couple of things. First is OIT, we support the notion of ongoing conversations that bring people to the table. If we widen the scope on AI, we expect to bring our chief data officer to the table. So a heads up for that. Second, with regard to what's on the screen now, the scope, I just want to reiterate that from this list, OIT absolutely has a direct impact on items A through its letters of intent, and definitely item E through the accountability report. So at some point, I look forward to getting on the agenda to bringing to this team what we've mapped out, how we want to execute on those two items and get consensus from the team. Does that sound fair?
That sounds great. Would you like to do that at our April meeting?
That sounds fair.
Great. Okay. That gives us a great agenda for our next gathering. We'll try to make it, again, 60 to 90 minutes and get through it. All right. Let's then turn to setting that date. So folks want to just take a quick look at calendars. Rectitone and my life are going to get worse. I'm thinking maybe the week of the 8th is the way to go. Senate will be done with the budget at that point. How do folks feel about a Monday or Wednesday afternoon?
Yeah, I have ag on Monday.
Okay, should we do the 10th?
Wednesdays are usually open in the afternoon, Tuesdays are also open.
3:30 to 5 on the 10th? Work for everyone?
Theoretically.
Yeah, they didn't do it.
I'm sorry, what time?
3:30 to 5.
I'd have to be remote if I could do that.
That's totally fine. Any objection from our folks on the Zoom? All right, look okay to you, Mr. Rubish? Okay. All right, very efficient today. Thank you, everyone. Looking forward to the discussion on the 10th. We'll have a draft to look at and decide if we want to make changes, adjustments, et cetera. It'd be a very good chance to have that full conversation with something in front of us. Yeah.
And if it's okay with everybody, I can call a JTC meeting on Tuesday morning, probably around 8:30. If it's only about this,
Yep.
hopefully we don't have any other business, to just talk about the introduction of the bill, because we have to vote on the introduction of the committee.
May I ask for 8 o'clock on the 26th?
No, we can work.
Yeah. Yeah, 8 should be great.
Okay, so it's 8 o'clock.
Yeah, and that's just so everybody, if they want to chime in at that JTC meeting, you can, or a proxy or anybody else you think might be interested. We'll just be discussing, should we do a bill?
And we can have you on, remotely if you, or in person if you like, we can meet across,
Right here. Yeah, just make sure.
And when we talk about it, you can chime in and say, if you want, you don't have to if you want to.
Yeah. Or an email to the committee like, hey, I think I'm on the task force and we should do this. That's fine too. But that'd be a great chance for our colleagues in the JTC to hear from the task force. All right, terrific, very productive, everyone. Thank you very much again for your continued engagement on this. Excited where we're headed next. We are adjourned.
Thank you.